We now turn to the fifth case on this morning's docket. It's case number 106103, State of Kansas v. Todd D. Schumacher.
If it please the court, Chief Justice Ness, I would request 3 minutes for rebuttal time if needed.
3 minutes is granted.
Thank you. Other justices, first I would point out that on May 2nd, I wrote a letter to the clerk under Supreme Court Rule 6.09b. Justice Moritz had the decision that was handed down. I used the WL site. It's the State v. Stimmick, STIMEC case. The site's 297 Kansas 126. Basically, this is a tragic situation where a lady was killed. An individual by the name of Todd Schumacher, after having multiple buttons pushed, decided he was going to go to his ex-wife's house, kill himself on the front porch so it wouldn't be a mess to clean up, and end his life and make sure that this Ann Schumacher had this vision in her mind the rest of her life. And the evidence shows that at the time he went over to the house, he waited until after normally the kids would be gone at school. And the neighbor's car that took him to school in the little town of Leota was gone. But unfortunately, the children were there. And one daughter, Miranda, had a camera. And when she heard her dad and her mom arguing at the front door, she turned the camera on primarily to capture the conversation. Mr. Schumacher was standing outside the front door of the house down. Mrs. Schumacher was standing, Mrs. Ann Schumacher was standing up about 12 inches higher than Mr. Schumacher when she answered the door. Part of the video, the whole evidence case here revolves around the comments that Mr. Carr made in rebuttal closing. And I have the greatest respect for Mr. Carr. We've had a lot of cases. And it pains me to use the language I have to use from the cases, but I believe it was improper what he did. While he may have had a good faith basis, it was totally in error. But in rebuttal, Mr. Carr says he's holding this gun and he's cocking it. And he's telling the jury, listen to the sound of cocking on the gun on this recording. I object. I say, Your Honor, I object. That's not in evidence. We go up to the bench, and the judge ruled that because the recording was in evidence, Mr. Carr was allowed to ask that question, and the jury could decide it. But I submit to you, one of the greatest rules there is no rule is governing oral argument is more fundamental than requiring counsel to confine their requests to matters in evidence, under State v. Bradford and all the cases afterwards. And of all the state's witnesses, there was even a Zachary Carr from the KBI, a firearms examiner that examined this pistol, said that it was in working order. It needed 3.5 pounds to pull the trigger. The trigger couldn't be set off by a sideways motion waving around, and that he had handled all these firearms. He was never asked, Sir, let me play this recording for you, and will you listen, sir, and tell this jury, do you hear the sound of what could be the clicking of a gun? Never asked of him. No fact in evidence ever asked of any witness. The officer that collected the gun was never asked, Sir, did you take this gun and listen to this recording, and will you cock this gun and see, do you hear a cocking noise? And the problem with that is when the state said this in rebuttal closing argument, you just went through the argument on what the law is and how the prosecutor's statement has to be outside the wide latitude, whether it's plain error, and then the second analysis, was it gross and flagrant, misconduct shows ill will, and whether there was direct and overwhelming nature of the misconduct likely to have any weight in the mind of the jurors. In this case, the daughter of Mr. Schumacher, who had to witness this tragedy, said her dad grabbed her mom, pulled her to him, took the gun, stuck it to her neck, and shot her. That was her testimony. I didn't cross-examine her. She believed she saw whatever she said. The coroner testified that Mr. Schumacher had to have been the gun. at least 1 to 3 feet away from Mrs. Schumacher when it went off, because there was no stippling in her neck. And in the coroner in the record testified that the gun was from front to back, left to right, which was consistent with Mr. Schumacher saying he knew he caused her death. His issue was, what responsibility should I have? And he said when he pulled this cocked gun out that he had stuck in his belt that had 1 live round that was set to fire, it also had 5 shells in it that were empty. And it's the same gun that 3 months earlier a suicide attempt he thought had happened. And we put on evidence about how he found with the same gun. This was Mr. Schumacher's way out. And the coroner testified that no, the shooting wasn't consistent with what Miranda testified to. It was consistent with he could have pulled the gun out, and when it was pulled out, it went off. And it went from front to back, left to right, and she was up. She died. Mr. Schumacher goes in. And the problem is the first question of the jury, after about 2 hours of deliberation, the judge instructed him on first-degree murder, second-degree unintentional, and then 1 other unintentional. And the question of the jury, which is in the record, was something to the effect, well, we're divided. 6 want premeditated and 6 want unintentional. Does that mean we have to find him guilty of second-degree unintentional? That was the first question. The judge then said, I have to refer you to the instructions. The jury then went back, and what did they do? The 6 people that were for unintentional played the recording over and over and over and over. And finally, one by one, they thought, well, it was clicking of the gun.
Where's that in the record?
Well, it's in the record on the motion for new trial. And
did you have affidavits? Or?
No, I don't have affidavits. While statements of counsel aren't evidence, this is the old courthouse on the 3rd floor, no elevator.
We don't have anything in the record to establish that.
I have in the record that the judge and Mr. Carr went and talked to the jury, first the judge and then counsel, and we were supposed to have an opportunity. Well, I'm loading my stuff in my car. I had to be taken down the stairs, and I had several carts. The jury's leaving, and so I didn't get a chance to interview them. But the judge and Mr. Carr all talked to the jurors, and they told them, and it's in the record. They played that tape over and over and over.
I'm asking, do you have an affidavit in the record from the judge or from the prosecutor saying that the jury told them this?
No, I don't, but I have statements of counsel on the record that I'm supposed to have candor to the tribunal that I repeated to the judge, but he told me because I didn't get my chance to talk to the jury.
The judge told you, this is your characterization of what the judge told you that you put in the brief.
Yes, and I put on the record the motion for new trial. The judge said the jury played it over and over. And the one juror that was in the courtroom crying, I put her name in the brief. She was the last one to change her mind. And it was all because of the recording. And so to say it had no effect or weight, and the reason I gave you a little bit of other evidence is, this isn't a case of overwhelming guilt. This is the case of, was it intentional or unintentional? And the jury deliberated over that for several hours. And the problem with this is, Justice Moritz, is when Mr. Carr made this statement, you can look through that record and you can look through the 2,037 pages of discovery, and I thought I missed something, and that there was some report that they had done this. No, but if you look at my Exhibit A, which is the motion for new trial attachment, had there been a question asked of any of the state witnesses, does the sound on this tape, this clicking noise, is it consistent with cocking the gun? What would we have done? We would have put on an expert. But you take this exhibit number A, and what does it say? On page 261, the record on appeal, this officer on April 29th says, the video moves about the room, and the camera's microphone scuffs against objects, causing noise to partially cover the voices at times. And what's that noise? Click, pop, click, pop, click, pop. And you can't tell if that's a clicking of a gun or clicking of the door, clicking of the scuffing. You don't know. And then he goes on to say, the expert, on page 262 on the record, that on May 12, 2010, I began working on the audio portion of this investigation. And 49.42 seconds into the file, right before the gunshot, he says, until that time, the female teen holding the camera scuffs the microphone as she moves and causes noises to be recorded, making the voices of the male and female talking at the door difficult. What did the noise? Pop, click, pop, click. And you see, there was no questions asked of the witnesses that the state put on. Is any of this popping or clicking on the enhanced or unenhanced video? Kicking of a gun? Yes, sir, Justice. I mean, yes, ma'am, Justice.
I'm just going to ask a question. As I understand it, your complaint is that this recording that was admitted into evidence had some noises on it, and the prosecutor was telling the jury, listen to the tape and see if any of the noises you hear are the cocking of a pistol. Am I correct so far?
I'm almost,
Okay.
Chief Justice.
Okay. And then the prosecutor cocked the pistol during his closing argument, which made a sound, and he's saying basically compare the sound that I just made, cocking the pistol, with the sounds you hear on the recording, and see if what you heard on the recording was in fact the cocking of a pistol. Is that right?
Yes, sir.
Okay. And your objection is because the prosecutor is the one who produced that sound, and it was not a witness who had cocked the pistol?
Absolutely.
All right.
It's that, Chief Justice, and also the fact that there was no evidence in the record. And if you look at all the cases that talk about what misconduct is, it talks about what was the evidence in the record. And just like in one of the cases where, I don't know if it was Fan, Brooks, Lye, or whichever one, but they said the color of the car is this color, and it wasn't. And there was no other testimony. And here, the judge said, well, the tape's in evidence, so the jury can use their common sense. Well, the jury had an unenhanced and enhanced tape, and the clicking noise that you hear on there, you can't tell if that's from the clicking of a gun or clicking, the scuffing of it. And you'd have to listen to the recording yourself, and the jurors did that for 2.5 hours until they changed from unintentional to intentional. And there was no testimony. So how can they use their common sense when they put on a firearms expert to say the gun's in perfect working order, and that it takes 3.5 pounds of pressure to pull the trigger, but then not ask the firearms examiner? You know what clicking sounds like? You ever heard a gun cocking? Now, did you take this gun, cock it, and listen to the tape, unenhanced or enhanced, and see if it was similar to that? No evidence of that, sir.
I'm sorry.
Was the gun itself admitted into evidence?
Yes, it was.
So if the jury had been allowed to take the gun back in the jury room, as they often do, photographs of their exhibits, and if the jury had been asked by the prosecutor, when you go back in the jury room, listen to the tape, if you want to cock the pistol and see if the sounds are the same cocking the pistol and on the tape, would you have any objection to that?
Absolutely. Again, because of the fact that there's testimony that the noise on the tape is messed up, and that noise is clicking, and it could be a gun or it could be it's a click, click, click. You got to hear it. And it's because of that I object. Because if it hadn't been for this enhanced tape, if it hadn't been for the operator saying the scuffing noise on the tape, I'd have no objection at all, because they could have done it. But when the witnesses aren't asked, the expert witness that handled over 400 firearms isn't asked to compare it. How can you expect 12 ordinary citizens to then compare when they're not even told, hey, by the way, there's enhanced clicking on this tape, and we enhanced that tape. So the clicking that was a little bit of clicking is now a lot louder clicking. And say, is that a gun cocking, being cocked, or is that clicking? The jury wasn't told that the tape had scuff noise on it and microphone problems. So that's why I objected, because there was not only was there no evidence in the record that the clicking on the tape was in any way related to a gun being cocked, when the state had a firearms expert there that could have said that. But number two, the state knew that the guy that enhanced the tape talked about the scuffing and the noise from the microphone on the camera, as is in Exhibit A for the new trial. So for those two reasons why I objected, Chief Justice.
Okay, thank you. Justice Moritz, you had a question or two, I believe.
Well, what difference would it make? I guess I want you to focus in on, let's assume you're correct, and let's assume that that's what the jury was doing, and that we can make that assumption somehow from the record. What difference does it make ultimately when there was a tremendous amount of testimony from several individuals who I don't think you challenged their credibility, saying that the defendant had indicated his intention to go and kill his ex-wife. And the only reason this business about whether the gun was cocked matters or not is because his story was that he had the gun cocked and ready because he was going to shoot himself, right? And that he had driven around with the gun cocked for 3 months. When what he testified, or what his story was?
Since this prior incident.
And something about because he was keeping it cocked and ready in his truck for a fire, in case there was a fire or something.
Well,
I mean, this was all, what I'm pointing to is this was all about his credibility. And ultimately, couldn't he have had the gun cocked and ready because he was going to kill her, which was what other witnesses testified to anyway?
Well, I'm glad you asked that, because no, that isn't what the witnesses testified to. If you look at the record, they said he made comments. Maybe he was going to kill her or harm her, but they took it to be his drunkenness and his state of mind, and they had no concern that he was going to act on that.
Well, they certainly did indicate a concern, and in fact, the sister-in-law had her husband, his brother, go over to the house to make sure he didn't come over there. She also said she was going to call the police if he did go over there. There was concern. I don't know how you could say there wasn't, but my point is, certainly there was testimony to support that he was going to shoot her, that was his point, and that's what he was there for. And why does it matter whether he had, couldn't he have had the gun cocked because he was going to use that one bullet to shoot her?
Sure, he could have, but if you look at the record, I specifically asked the witnesses, did you think he was going to kill her? Did you believe he was going to kill her? Did you believe that statement was he was going to kill her? And the responding answer was no, no, no. And she didn't say she was going to call the police if she came over there. She said if he was concerned he was going to harm her, she would have called the police other than her husband. But he could have had the gun cocked to go over there. Yes, Justice Moore.
I understand you're making a jury argument, and I get that. I'm just trying to get you to isolate what,
And why I'm isolating it is because the coroner's testimony, that showed doubt of what happened by the state's theory, and it harmed the state's theory because Mrs. Shoemaker was higher than Mr. Shoemaker, and she was shot with the bullet going upward, front to back, left to right. He had plenty of other weapons. He could have killed her if he wanted to. And yes, he could have had that one bullet and just said, well, you're dead, boom, and shot her. But that wasn't the coroner's testimony. That wasn't the facts. And the only statements of the witnesses, yes, he made those about that we were going to harm her, but the ones that knew him best, 32 years, 27 years, said it didn't matter. And also, this was a gun he bought in college when he was 21, 20-some years earlier, and the bullets were old bullets from 21 years older, and he had one left. And as he testified, and others testified, that was considered his way out. So yeah, he could have been over there to kill her. But if you take the fact that he waited till after the school bus was supposed to pick them up, number one, or the neighbor took him. Number two, he stayed on the front porch. He never went in the house. And he said he did that so there wouldn't be a mess to clean up. People that have suicide do things like that, and that are committing suicide, and the jury can weigh it. And those 6 jurors that were considered divided after several hours of deliberation about the unintentional versus intentional, then they listen to the recording and they say, well, it must have been clicking. Yeah, he must have cocked the gun before he shot her. His credibility shot to hell.
Mr. Rourke, did I remember correctly that defense counsel cocked the gun in closing?
Not me. The state did, Your Honor.
Okay.
No way did I cock that gun. Absolutely, positively not. The state did it in rebuttal, so I wouldn't have had a chance to cock it. There was no mention of cocking the gun at any time before the rebuttal testimony, not even in the case in chief. So how can you put on evidence to something that you have no evidence, anything in the record to use, other than you have the recording itself? And just to give you a quick example, I was in a jury trial in Johnson County 3 weeks ago, And it was road rage, and the guy charged with ag battery, deadly weapon.
Is this going to be in our record on appeal, counsel?
No, just an example purely for purposes of illustrative how a judge ruled.
Well, you're well out of time. Can we
That's
save the
fine.
example for your rebuttal?
That's fine. I will, Chief
Thank you.
Justice. Is there any other questions? I'm out of time.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. The reason I thought that perhaps defense counsel had cocked the weapon is based on page 404 when he says, but if it's cocked like this and I move the gun around, I could be wrong. I was reading a cold record. I don't know one way or the other on that one. But as to whether or not the gun was cocked during the evidentiary portion of the trial, was indeed actually done on page 484, that if, I believe it's the gun expert testifying, he says, and he goes through and he's just demonstrating to the jury exactly how the gun would be used and the amount of pressure. And he specifically says, I had it here, and then of course I can't underline it. So what happens is I will push it forward on every chamber, and then I'll let it down, I'll cock it back again, load up another chamber, push it forward to see if it will push off. The cocking was in evidence. Furthermore, as this court has already noticed, or questioned the defense on, the gun was submitted back to the jury. In fact, defense counsel sent gloves so the jury would be able to mess with it. Both the original audio recording and the enhanced audio recording were played in front of the jury. The gun was cocked in front of the jury. The fact that the clicking noise was the gun cocking, that was a reasonable inference. There was simply no misconduct part of the prosecutor in this case, based on that reasonable inference.
Well, is that a reasonable inference? I mean, the fact that the gun was cocked in front of the jury is one thing, but to tell the jury that the sound they're hearing on the recording is the gun cocking, that takes another step. And is that something the prosecutor can make that step in closing argument?
The prosecutor and the jury are equally equipped to be able to determine whether or not they think the clicking noise matches. That is absolutely a reasonable inference that any person can make. I can sit there and say, I clicked a pen. Does that sound like a clicking pen? We can all do that. There's nothing.
But there's another inference they have to make, and that the fact that they sound alike, that they also were one and the same thing, that it wasn't some other sound. There's a third connection they got to make, which is even that it not only sounded like a clicking, but it was the clicking. Does that make sense?
But the prosecutor doesn't have to rule out every alternative theory in order to make a reasonable inference. To make a reasonable inference, the prosecutor just has to say, they sound alike, it probably is the cocking of the gun. I can't see how that is not a reasonable inference on the part of the prosecutor. I think at one point she gasped, and they say she gasped. Can we not make that inference either? Because no one specifically testified that was a gasping. That's allowed, so I don't see the difference between that and the clicking. I'm going to also, and in the brief, he points out, well, had we done it earlier, if we'd had an expert put on to say, yes, that is the clicking, the cocking, he could have rebutted that. That doesn't have anything to do with whether or not there was prosecutor misconduct. His ability to provide a rebuttal has zero impact on reasonable inference of prosecutor misconduct. In his motion for a new trial, if he had a witness that could have disputed that it was the clicking, he could have put that on. And in fact, in order to grant the motion for new trial, he would have had to do that because he can't prove prejudice until he can actually find an expert or anyone else to say, no, that wasn't the cocking of the gun. And then on the justice for the victim, I recognize that this court has said that the prosecutor is not allowed to argue justice for the victim. I respectfully disagree with that argument. And it is usually based on the argument, I'm going to pronounce the case Nguyen, because that's how I was told it was pronounced, Nguyen, I don't...
Nguyen.
Yes, that
Nguyen.
case. I'm going to say Nguyen, if that's all right. That case doesn't go so far as to say the prosecutor can never ask for justice for the victim. They say The concern essentially is whether or not the prosecutor is trying to get the jury's sympathy. Well, in this case, the prosecutor specifically said, sympathy does no good. Don't rely on sympathy in this case. So that concern is not present in this case. So simply asking for justice for the victim, which...
But that's wrong. That's wrong. The prosecutor does not represent the victim. The prosecutor represents the state of Kansas, and it's obtained justice for the state of Kansas and all its peoples, not the victim.
Right, but that also is through obtaining justice through the victim. They're not something you can separate out. The reason we're in that courtroom is for the victim, to get justice for the state because of the victim.
Well, I guess we could have differing opinions, but if the prosecutor represents the state of Kansas, it's to enforce the rule of law, not to obtain justice for the victim. That's a civil case can do that for the errors of the victim.
The civil case, I don't know if monetary justice, yes.
But be that as it may, the prosecutor, you would agree the prosecutor represents the state of Kansas.
I do absolutely
and
agree
not
with
the
that.
victim.
The victim is right, yes. But I do think it is hard to divorce the two, and that's why the court in Wynn said that the central issue should be whether or not they're asking for sympathy. Here they weren't. There was no prosecutor misconduct, but even if there was very strong, if not overwhelming evidence in this case. There were multiple threats against the victim, and I get that defense counsel thinks that family didn't believe the threats, but they took actions inconsistent with that. They tried to protect Anne from her ex-husband in this case, and they wouldn't have done that if they thought, oh, he's just kidding, ha ha ha, or if they weren't serious about the threats. Then, after he apparently supposedly was trying to kill himself, instead of rendering aid to his very hysterical children, he walks away calmly, goes to the sheriff's office, and chuckles. This is all inconsistent with the suicide. The evidence here supports first-degree murder, and nothing the prosecutor said would have impacted that evidence. So the state would respectfully ask that you confirm the conviction in this case. Convictions.
Any questions of counsel?
Can you address the jury question that came up about convicting of second degree? Can we convict of second degree? Apparently they were kind of hung up, and they asked about convicting of second degree. Mr. Rourke says after that's when they watched this video and then we're able to come up with this.
One, as you pointed out, there are no affidavits in that, so I'm not really sure how strong that evidence is because we can't rely on evidence of statements of counsel. But even if the jury did listen to that tape over and over again, the tape also has other value besides just hearing a clicking. But I still don't see how that was prosecutorial misconduct to have them play the tape. So the number of times that they played the tape really has no impact if there was no prosecutorial misconduct in the first place.
Any other questions? Thank you, counsel.
Thank you. And in rebuttal, Chief Justice, I should apologize. I took your question to mean during closing argument, did I cock the gun? And my answer is emphatically no. The statement referred to by the prosecutor, or the Solicitor General, page 484, that's examination of the firearms expert by Mr. Carr. And on page 484, I don't get into my cross-examination until 501 on the record. And I haven't finished reading it yet, but I may have asked the officer questions and I may have handled it on my cross. I don't know. I just found it. But if I did, it would have been when that person was testifying, sir. And the question that the state brought up, page 484, that's the prosecutor asking the expert to take the hammer back and show the jury how they tested it and to show them how it works. And it's the expert saying, now I've cocked it. And so you would have heard a click then, and that would have been the time to say if there was any question about cocking on the tape. Well, sir, you're cocking that now. Now, have you listened to this recording? And Justice Morris, the recording that was in question was just audio because they took the video and made some exhibits, and then they took the audio and made some exhibits. So it's only audio. So the jury just played this disc over and over and over. And that's what the judge told me. I never got a chance to talk to the jury. And so I believed the judge, and that's why I said it in my motion for new trial, because he told me that. And so I figured what he said it happened as an officer of the court. But the firearms expert does cock it and does put gloves on when he's there. And that's why I gave the gloves, is because he said earlier in his testimony, you got to have those on when you're handling it. I didn't give the gloves for the jury to go back there and cock it. But anyway, he talks about the hammer resting and the very small notch on the hammer. And so that's questioning by the state. And I don't know, I haven't read 501 to 508, but I don't think I did cock the gun. And if I did, it would only have been in response to questions he had about how much took to pull the trigger. It had nothing to do with the sound of cocking of this gun. Doesn't in any way relate to the tape, because there was no issue, justices. Any time for the year prior, there was never a question that there was sound of cocking of a gun on the tape. It only came up in rebuttal of the state's case. That's the first time it's mentioned. There's nothing about this in any of the state's case, any of the state's witnesses, anything in the reports. There's nothing about cocking noise on the tape. And I only got 37 seconds left. So I'll tell you, the example I had was the aggravated battery. The guy says, I drive from this grocery store in Lenexa to 87th Street in DeSoto. I took this street. And the question was whether he was doing 39 miles an hour going down one hill. Right before closing argument, my client said, hey, there's 2 hills on that route. Well, I said, well, now's a fine time to tell me. There's no more evidence goes in. And so I'm arguing. I said, well, let me see what I can do. So in argument, I say, well, judge or jury, there's a road here, and you can use your common sense. You know it runs from here to here, and there are 2, and before I can say hills, the state objects. So they knew what I was up to. The judge said, well, there may be 2 hills, but it's no evidence testifying that there were, so it's not in the record. You can't ask them that. That just gives you the opposite side of looking at things. So that's all I want to tell you. It doesn't mean anything on this case, but it's just an example of how things are. If there are any other questions, I'll let you go lunch. I mean, not let you go, but I'll leave so you can go.
Any more questions? Thank you, counsel.
Thank you.
Thank both of you for your arguments this morning. The court will take this matter under advisement. That